let me go back to some very 101 level basics of Chapter 15. Similar to Chapter 11, you commence a Chapter 15 case by filing a petition, which there's some basic paperwork that includes a declaration in support of the recognition, the relevant papers from the foreign proceeding, the plan or commencement application, the foreign representative statement and appointment either by the company or the foreign court. And once the case is filed, unlike a Chapter 11, the case is yet to be commenced or recognized. It started, is like sort of what I like to think of it, but there's ultimately a hearing, typically within 14 or 21 days, to actually hear whether or not the case should be recognized as a foreign main or a foreign non-main proceeding. In certain urgent circumstances, accompanying the petition can be a motion for expedited relief for interim recognition until a hearing can be held on the actual recognition. We call that the gap period relief. And during that gap period, a U.S. bankruptcy court, subject to meeting certain evidentiary thresholds, akin to a temporary restraining order sort of standard, you have to show there's an urgency and a need and a necessity that, but for the gap period relief on an automatic stay or other provisions that are necessary, the estate could be harmed or the foreign proceeding could be jeopardized as a result of actions adverse by creditors or other parties in the United States. So there is a way to bridge the gap, if you will, between the actual filing of the petitions and then the hearing to recognize. And it's actually very straightforward. If you meet a certain set of requirements, that is a foreign proceeding, that there's a foreign representative, there's a debtor, then the bankruptcy judge is required to, it's a shall recognize. And if it's a location where the comia is, then it's going to be a foreign main proceeding. And if it's not where the comia is, but where they regularly transact business, then that could be a foreign non-main proceeding. There are different triggers that emerge upon recognition as a foreign main versus a foreign non-main. Foreign main is where the automatic stay automatically kicks in and various other provisions of the bankruptcy code are just automatically brought into fore. Whereas in a foreign non-main proceeding, it's up to the discretion of the parties to request the relief and the court to grant the relief requested. Substantively, there is no difference between the two if a foreign non-main is recognized and the debtor effectively asks for all the benefits and provisions of a foreign main. So you can achieve very similar outcomes. It's just about the procedural path that you go through in order to have the recognition.